Within the field of social work, the way in which professionals engage with the use of relationships is integral to the development and understanding of professional practice. Whilst professionals strive for change within society, quite often the profession is bound by a framework of rights and duties. The human services domain is often constrained by a number of laws, employment policies, and codes of professional conduct that effectively define individual practice within the field. One key context of influence is the legal system and its parameters. Social workers become involved with the law and the legal system under various circumstances, and research has shown that interaction with lawyers and legal systems are a contributing factor in worker burnout rates. Often, these disputes are between the worker and lawyers, which are centred around their respective attitudes and roles that contribute to social issues. The political, social, and legal structures within a community give insight into the laws and processes that underpin attitudes adopted towards minority and marginalised groups of society. It is of a worker's role to overcome such prejudices and strive for non-judgmental, supportive, and affirming relationships based on intervention at whatever level necessary. In this, it is important to note that in doing so, social workers are not confined by law. Rather, they are there to build relationships with service users who may find the law and legal systems remote, complicated, unsympathetic, unwelcoming, and expensive. Although Australia has inherited key aspects of its legal system from the United Kingdom as part of the Commonwealth, Australian political and legal systems operate on a two-tiered basis at a federal and state level. The legacy of the Westminster system, passed down from Australia's English heritage, is seen within the government and judicial system based on a common law. As a consequence, law derives from two main sources, those being statute and common law. Statute law is a body of law that is enacted by the 9 parliaments, that is, 1 Commonwealth, 6 states, and 2 territories. Whereas common law is conversely the body of unenacted laws that emanate from courts at a federal, state, and territory level. The Commonwealth Parliament and the Parliament of each state are bicameral, which means and consists of both an upper and lower house. In Queensland and the Northern Territory and the Australian Capital Territory, the parliaments only use one legislative house. The lawmaking processes within Australia begins with a proposal for making a law which may come from government or pressure groups. Parliamentary drafters then draft a bill and the relevant minister initiates the bill in Parliament. The bill undergoes a number of stages where it is deliberated in detail. If the bill is passed by the lower house by a majority vote, the bill is sent to the Governor, if state bill, or Governor-General, if it's a federal bill, for royal assent. Within the states of Australia, common law, which is also recognised as a judge-made law, is law that has been developed from judges handed down in court. It is mostly used to make decisions about areas that are not necessarily included in the Acts of Parliament and determine the outcome of cases along the lines of earlier decisions and similar cases. This type of law is often seen within the confinement of the Magistrates' Court. The Magistrates' Court of Australia is the lowest court of the Victorian court system, with the County Court of Victoria and Supreme Court of Victoria respectively higher. A typical magistrate's courtroom consists of a witness box, a public gallery, the bar table in which both parties sit, a raised bench for seating and sitting the magistrate, and a dock in front of this to sit the court clerk. Whilst the magistrates court hear a number of cases of diverse nature, family and family violence matters frequent the hearings. Family violence is when someone behaves abusively towards a family member. It is part of a pattern of behaviour that controls a person and causes them fear for their own and others' safety. Violent and abusive behaviour includes physical and sexual violence, financial and emotional violence, and psychological abuse. In drawing focus to the sexual abuse of a minor within the law constraints of Victoria, the age of consent stands at 16. The law, however, does allow sex between two young people of similar age. However, sex between an adult and a young person is seen as criminal activity. It's important to note that a person aged between 12 and 16 can validly consent to sex without a person who is not more than 2 years older than him or under her. Under Victorian law, a person aged 16 or older can validly consent to sex with a person except a person who is in a position of authority over them. Under Section 49 of these Crimes Act, it is a criminal offence for a person to sexually penetrate a child who is 16 or under the person's care of supervision. As outlined in Section 49B of the Crimes Act, it is also a criminal offence to sexually penetrate a child under the 16 and people who do this can serve a maximum of 15 years imprisonment. In 2004, the Victorian Sex Offenders Register started in 2004 and is governed by the Sex Offenders Registration Act. Persons found guilty of the certain types of sex offences are required to register this legislation so that the police can track their whereabouts to reduce their chance of reoffending. In summary, within our visit to the Bendigo Magistrates Court on Wednesday, April 7th,